Carla Faye Tucker. On the morning of June 13th, 1983, a man named Gregory Scott Traver drove across northeast Houston to pick up a co-worker for a shift the two of them were supposed to be working. The apartment door was open. What Traver found inside would eventually put a 23-year-old woman in the Huntsville death chamber, and it would take almost 15 years to get her there. By the end of it, she had become the most recognizable condemned prisoner in America, and a televangelist, a homicide detective, and the brother of one of her victims were all asking the governor of Texas to let her live. Jerry Lynn Dean was 27 years old, a cable television installer who was in the middle of separating from his wife, Shawn. Deborah Ruth Thornton was 32, an office worker who had argued with her husband that weekend and gone out to a party to get away from the house. She met Dean there and went home with him. She had never met Carla Faye Tucker, and Tucker had no idea anyone else would be in that apartment. Tucker was born in Houston on November 18th, 1959, the youngest of three sisters. Her father worked the ship channel as a longshoreman. Her mother traveled with rock bands and used drugs openly in front of her children, and Carla followed her into that world almost as soon as she was old enough to walk out the door. She was smoking marijuana at 8, using harder drugs by 10, and out of school for good at 14. Somewhere in the middle of her parents' divorce, she learned that the man she had called her father all her life was not her biological father. She married a mechanic at 16, and by the summer of 1983 she was divorced, 23, and living with Daniel Garrett, a man 14 years older than she was. The weekend of the crime, Tucker, Garrett, and a third man named James LeBrant were 3 days into a binge of pills, speed, marijuana, and alcohol. Tucker carried a grudge against Jerry Dean. He had once rolled a leaking motorcycle into her living room, and he had ruined a photograph of her with her mother, which she never let go of. Weeks earlier, she had quietly lifted a set of his apartment keys off Shawn Dean's keyring. The stated plan, as everyone told it afterward, was to take a motorcycle out of the apartment. In the early hours of June 13th, they let themselves in, and Dean woke up. Tucker attacked him with a pickaxe, and he did not survive. The medical examiner would later document roughly 28 separate wounds, along with a skull fracture from a hammer. Deborah Thornton had been lying hidden under the bedding on the far side of the room through all of it. She was harmed fatally, so that she could not describe what she had seen. The pickaxe was left behind in the apartment. Tucker later testified that she had felt a rush of physical pleasure with every swing. Stated plainly, she told a courtroom that she had enjoyed it. The case might have stalled there because nothing at the scene pointed at her. What ended it was her own mouth. She told Daniel Garrett's brother, Douglas, exactly what the two of them had done, almost as a joke. Douglas burned Dean's wallet to help them, then spent weeks unable to sleep with it, and finally went to a family friend who happened to be a Houston homicide detective named J.C. Mosier. Douglas agreed to wear a recording device. On tape, Tucker discussed that night in the same flat, unbothered tone. She was arrested on July 20th, 1983. So what does a courtroom do with a defendant who has never denied a single fact? She was tried in Harris County, in the 180th District Court, and she pleaded not guilty anyway. The jury convicted her of capital murder on April 19, 1984, and returned a sentence of death 6 days later. Garrett was tried separately and also condemned, though his conviction was later overturned, and he died of liver disease in 1993 while awaiting a new trial. Tucker testified against him, and in exchange the second capital charge covering Deborah Thornton was dropped. Her direct appeal, published as Tucker versus State, changed nothing. She had already spent 4 years on death row by the time that opinion came down, and she would spend 10 more. Texas had not put a woman to death since 1863, and the only woman executed anywhere in the country since capital punishment returned in 1976 was Velma Barfield in North Carolina in 1984. For most of Tucker's years at the Women's Unit in Gatesville, the working assumption inside the prison and outside it was that some court would eventually step in. The argument her supporters built was narrower than most people realized. They never claimed she was innocent, and neither did she. What they argued was that the woman scheduled to die in 1998 had spent 14 years taking responsibility in full and working with other prisoners, and that she posed no danger to anyone. Prosecutors answered that the question in front of the state was not who she had become, and that nothing in those 14 years had changed what happened in the apartment. What happened after that had almost nothing to do with the law. Tucker converted to Christianity in the Harris County Jail while awaiting trial, and over 14 years on death row, that conversion became an international story. Pat Robertson campaigned for her. One of the detectives who had worked the case asked the state to spare her. So did Ronald Carlson, Deborah Thornton's own brother, who came to know her, forgave her, and begged Texas not to proceed. She sat for a Larry King interview on January 14, 1998. In her own clemency letter to Governor George W. Bush, she wrote that justice and law demanded her life for the 2 innocent lives she had taken, and that if her execution was the only thing that could answer that demand, she accepted it. The Texas Board of Pardons and Paroles denied clemency on February 2nd. Bush refused a 30-day reprieve, saying she had acknowledged her guilt of a horrible crime and asking God's blessing on her victims and their families. His spokeswoman noted that the gender of the person responsible did not change the fact that 2 people were gone. She was taken to the Huntsville unit on February 3, 1998. Roughly 200 reporters from around the world stood outside the walls, alongside more than 25 satellite trucks and a crowd of over 500 people. She asked for a banana, a peach, and a garden salad with ranch dressing. She was statewide execution number 145 and inmate number 777. In her final statement, she apologized to the Thornton family and the Dean family, told them she hoped God would give them peace, and said she would be seeing Jesus in a moment and would wait for the rest of them there. Richard Thornton, Deborah's husband, watched from the witness room and spoke aloud to his late wife as the drugs began. Tucker gasped, coughed twice, and was pronounced dead at 6:45 that evening. She was the first woman Texas had executed since 1863, and only the second woman executed anywhere in the United States since the death penalty returned in 1976. As of today, Carla Faye Tucker is buried at Forest Park Lawndale Cemetery in Houston. Ronald Carlson, who lost his sister in that apartment and then asked the state to spare the woman responsible, went on to speak publicly against capital punishment for years afterward. Tucker's case was argued almost entirely over whether the woman on the gurney was still the woman from the apartment. The next woman Texas put to death never asked anyone to believe she had changed, because she never conceded there was anything to change. Betty Lou Beets. In August of 1983, a retired Dallas fire captain named Jimmy Don Beets went out on the water near his home in East Texas and did not come back. His boat turned up drifting with his fishing license, his heart medication, and a life jacket still aboard, and everyone in Henderson County assumed the lake had taken him. His wife told that story for nearly 2 years. He was buried the entire time in the yard of their trailer, underneath a decorative wishing well. Jimmy Don Beets was a retired fire captain, well-liked, and by all accounts the most stable of the 5 men Betty Lou Beets married. He was her 5th husband. Doyle Wayne Barker, her 4th, had vanished in 1981 and was never recorded as anything more than a man who walked out on a marriage. He was buried on the same property, under a shed. Betty Lou Dunavant was born in Roxborough, North Carolina, on March 12, 1937. A childhood illness left her partially deaf. She described a childhood of sustained abuse beginning around age 5, and her mother was institutionalized when Betty was about 12, which left her raising her siblings. She married for the first time at 15 and would marry 5 times in all, working as a cashier and a waitress along the way. Her marital history included violence that ran in both directions. She had shot her 2nd husband in the back, and she had tried to run her 3rd husband down with a car. Both men survived, and neither case sent her to prison. On August 6, 1983, she reported Jimmy Don missing. The boat was found. Search crews dragged the lake. The prosecution's account, assembled 2 years later, was that she had approached him while he slept and taken his life with a .38 caliber pistol, then set the boat adrift to sell the drowning. 2 bullets were eventually recovered from his remains. The motive was a firefighter's pension and a life insurance policy. Her own son, Robert Branson, testified that his mother had told him beforehand what she intended to do, told him to leave the house, and then had him help bury the body. You would think someone would have said something. Nobody did, for 2 years. In June of 1985, a tip about foul play sent investigators onto the property with shovels. They found Jimmy Don Beets in the yard. Then they found Doyle Wayne Barker. Betty Lou Beets was arrested that month, and she was charged in Barker's death as well, though she was never tried for it. If a jury never hears half of a defendant's life, are they really sentencing the person in front of them? She was tried in Henderson County and convicted of capital murder on October 11, 1985, on the theory of murder for remuneration, meaning she had done it for money. She was sentenced to death 3 days later. Her own children testified against her, including about the burials, and she attempted to shift responsibility for the shooting onto her son. The defense raised self-defense and battered spouse syndrome, but developed neither in any serious way. The reason for that surfaced later and became the most disputed feature of the entire case. Her trial attorney had accepted the literary and media rights to her story as his fee. That arrangement created a conflict of interest, and it meant he could not take the stand himself to testify that his client had only learned of the pension and insurance benefits a full year after her husband's death. The jury never heard it. Prosecutors called her the Black Widow, and the label attached itself to the case for the next 15 years. The money at stake was not enormous, but it was specific. As the widow of a retired Dallas fire captain, she stood to collect his firefighter's pension and the proceeds of a life insurance policy, and neither of those could be paid out while he was merely a missing person, presumed drowned. That is the whole reason the state charged murder for remuneration rather than plain murder, and it is what made the case capital. Doyle Wayne Barker's death was charged separately and never tried, which meant the jury, weighing whether Betty Lou Beets should live, heard about a second husband buried on the same lot without a single piece of that evidence ever being tested by a defense. Her appeals ran through the Texas Court of Criminal Appeals as Beets versus State and eventually reached federal court as Beets versus Texas Board of Pardons and Paroles. Amnesty International took up her appeals, documenting a history of severe physical and sexual abuse, head injuries, and post-traumatic stress that had never been presented at trial. She sued the Texas Board of Pardons and Paroles directly, arguing that battered women deserved a distinct standard of clemency review. The board denied her clemency 15 votes to nothing. Governor Bush's office recorded more than 2,100 calls and letters urging him to stop the execution, against 57 asking him to let it proceed. He declined a 30-day stay in the middle of a presidential campaign, stating that he concurred with the jury and that the courts, including the Supreme Court, had rejected every appeal she raised. Her attorney told CNN that she was frightened and that what she dreaded most was being strapped to the gurney alone. The amnesty report made a narrow institutional argument rather than an emotional one. It held that Texas had never actually examined whether decades of documented head injuries and abuse had shaped the woman the jury saw, and that a clemency system with no standard for weighing that history could not honestly claim to have reviewed it. The board's answer came back 15 votes to nothing, and like nearly every Texas clemency decision, it arrived without a written explanation. She had spent 14 years on death row, most of it at the women's unit in Gatesville, and she was moved to Huntsville only for the day. She arrived at the Huntsville unit on February 24, 2000. She was 62 years old, a great-grandmother, statewide execution number 208, inmate number 810. She declined a last meal. She declined a final statement. She smiled at her attorney and her pastor through the glass, coughed twice, and was pronounced dead at 6:18 that evening. No one from her family attended. The sons of both buried men did. Jamie Beets said afterward that he had focused on his father and that he knew his father was smiling and that it was finally over. Rodney Barker said it felt like weight coming off him. A journalist in the witness room, Michelle Lyons, wrote later that she could not stop looking at how small the woman's feet were, and that she looked like somebody's grandmother, because she was somebody's grandmother. Beets was cremated, and her ashes were scattered over her mother's grave. As of today, Betty Lou Beets remains the oldest woman Texas has executed in the modern era, and her case is still cited in arguments over how the courts weigh long-term domestic abuse when it arrives late and through a lawyer with something to gain. Beets went to the chamber without saying a word, having spent 17 years insisting on a version of events almost nobody believed. The third woman also refused to speak at the end, but for the opposite reason. She had said the same thing for 18 years, and there was no longer anyone left to say it to. Frances Newton. 3 weeks before her family died, Frances Newton took out 2 life insurance policies. That was the fact the state of Texas built its case around, and it was enough to carry her to the death chamber 18 years later. But the crime lab that handled the evidence against her would eventually be described in a national newspaper as possibly the worst in the country. The piece of clothing at the center of the case could never be retested, and 3 of the jurors who convicted her said afterward that they would have voted differently if they had known everything. Adrian Newton was 23 years old. He and Frances had married young, and by the spring of 1987, the marriage had effectively ended, though the 2 of them were still sharing an apartment on West Mount Houston in Harris County. They had 2 young children. Adrian's brother, Sterling, was living there with them. Frances Elaine McLemore was born in Harris County on April 12, 1965. She finished the 12th grade. She had a 1985 forgery conviction that carried 3 years of probation, and a former employer who would later tell a jury she had been fired for theft, a detail the state used to considerable effect. She was 21 years old at the time of the crime. On the evening of April 7, 1987, Sterling Newton returned to the apartment. Adrian had been fatally shot. The couple's 2 children had also lost their lives. Frances called for emergency help. Prosecutors would describe the scene to jurors as deliberate and methodical rather than the product of any struggle, and they told the jury the answer was in the paperwork. On March 18th, less than 3 weeks earlier, Newton had taken out $50,000 life insurance policies, naming herself as the beneficiary. She filed the claims on April 21st. She was arrested and charged on April 22nd. At trial, the state called Sterling Newton, along with a series of relatives and acquaintances, including Ramona Bell, Alphonse Harrison, Sandra Nelms, and Jeffrey Frello, and assembled a portrait of a woman who had been unnaturally composed in the hours afterward and unusually precise about paperwork in the weeks before. Newton's own account never shifted in 18 years. Speaking from death row, she said she had been frightened and confused, that her family was gone, and that the people who were supposed to be finding out what happened had decided it was her. She was 21 when she was arrested and 40 when she died. The physical case came down to 2 things. A .25 caliber pistol belonging to a man Newton had been seeing was recovered from a paper bag hidden in an abandoned house after a witness reported watching her put it there, and ballistics tied it to the scene. And technicians with the Department of Public Safety reported finding nitrite residue near the hem of a skirt she had been wearing. Newton's explanation for both was consistent from the first interview onward. She said she had found the pistol in her home, believed it belonged to the man she had been seeing, and moved it out of the apartment for safety. She said the residue was fertilizer, picked up at a relative's house with a large garden where her youngest child had spent that day. Her court-appointed trial attorney was Ron Mock, a name that would later become shorthand in Texas for inadequate capital defense. He was eventually barred from accepting capital appointments. He acknowledged that he had been burned out, that he had done almost no independent investigation, and that he had subpoenaed no witnesses for the defense. Newton was convicted of capital murder on November 17, 1988, and sentenced to death. If the evidence that convicted someone can never be examined again, how is a court supposed to measure doubt? That question drove 17 years of appeals. The defense theory was that a drug dealer had come to collect roughly $1,500 Adrian owed. A relative in custody reported that a cellmate had boasted of going to the apartment over a debt with instructions to leave no one behind. Then the ground shifted underneath the state's forensics. Newton had been prosecuted in Harris County, home of the Houston Police Department Crime Lab, and by March of 2003, the New York Times was publicly asking whether it was the worst crime lab in the country. A Texas Senate resolution from that same legislative session cited a state auditor who called the Houston lab among the worst she had seen in nearly 20 years, and noted that more than 200 Harris County capital cases were under review. And somehow, it gets worse. The skirt could not be retested because the 1987 testing had destroyed the nitrite particles, and because the garment had been stored in the same bag as clothing belonging to the victims. No blood was found on Newton's clothing, her hands, or her car. The state's own timeline required her to have done everything, cleaned herself completely, and driven to her cousin's home in under 30 minutes. There was also a lasting dispute about how many guns had ever been involved. A Houston police sergeant named J.J. Freeze testified that investigators had discussed 2 pistols, that he was certain of one, and that there had been mention of a second one Newton had purchased earlier. The second pistol was never produced, never tested, and never explained away. 3 of the jurors who voted to convict her said afterward that they would not have done so if everything now known about the case had been placed in front of them at the time. Governor Rick Perry granted a rare 120-day reprieve on December 1, 2004, roughly 2 hours before she was scheduled to die, so the evidence could be examined again. The courts ultimately found it sound. The Board of Pardons and Paroles denied clemency. Amnesty International, the NAACP, and community leaders in Houston appealed publicly. David Dow of the Texas Innocence Network argued in the clemency petition that the state's theory was simple and superficially compelling, and that appearances could be misleading. Deloyd Parker of the Shape Community Center put it to the governor more bluntly, saying that if they were wrong, there would be nothing anyone could do afterward to fix it. She was executed at the Huntsville unit on September 14, 2005, as statewide execution number 349 and inmate number 922. She declined a last meal. Asked for a final statement, she shook her head and said no. Her parents and her sisters watched. She was pronounced dead at 6:17 that evening. She was the first black woman Texas had executed since the Civil War. As of today, her conviction stands, and no court has ever declared her innocent. Her case remains one of the most frequently cited in the country by the Death Penalty Information Center and the Texas Innocence Network, and it comes up in almost every serious discussion of court-appointed counsel and forensic reliability in Harris County. Newton's case turned on whether the science could be trusted. The one that follows turned on something simpler and much harder to argue away, which was the question of who was permitted to sit in the jury box in the first place. If you're liking this video and you're not subscribed yet, now's the time. We drop new cases every day. Subscribe so you don't miss the next one. Kimberly McCarthy. On a July afternoon in 1997, a retired professor in the Dallas suburb of Lancaster opened her front door because her neighbor had run out of sugar. That was the pretext, and it worked. 16 years later, the woman who used it became the 500th person Texas had executed since the state resumed executions in 1982, a number that brought reporters from 4 continents to the Walls unit. What most of those reports left out was that at her second trial, only 4 of the 64 people summoned as potential jurors were black, and the prosecution struck 3 of them. Dorothy Booth was 71 years old, a retired psychology professor who had spent her career at El Centro College in Dallas. She lived alone in Lancaster and still wore her diamond wedding ring. Her neighbor was Kimberly McCarthy. She knew her well enough to open the door without thinking twice about it. McCarthy was born Kimberly LaGale McCarthy in Greenville, Texas, on May 11, 1961. She trained and worked as an occupational therapist, most of it in nursing homes, which meant her working life was spent caring for elderly people. She had been married to Aaron Michaels, the founder of the new Black Panther Party, for roughly 3 years in the mid-1990s, and they had a son together. By the summer of 1997, a crack cocaine addiction had taken over everything else, and it was the addiction, not the marriage or the career, that the jury would hear the most about. On July 21, 1997, McCarthy called Booth and asked to borrow a cup of sugar. Booth let her in. McCarthy attacked her with a candelabra and a butcher knife, and Booth did not survive. Before leaving, McCarthy took the diamond wedding ring off Booth's hand, severing the finger to get it. She took the purse, drove Booth's car away from the house, bought crack cocaine, and pawned the ring. The ring brought about $200. That is not a typo. Booth's credit cards were used repeatedly over the following hours, including at a liquor store, which is roughly how long it took investigators to establish who had been in the house. She was charged the day after. The evidence stacked quickly. Booth's driver's license was in McCarthy's possession. Booth's DNA was on the weapon recovered from McCarthy's home, and the credit card transactions placed her everywhere she claimed not to have been. In a written confession, McCarthy said 2 drug dealers had pressured her into setting up the robbery and had done everything themselves while she waited outside. The jury did not accept it. Then, during the punishment phase, prosecutors introduced DNA evidence tying her to 2 more deaths from December of 1988. Maggie Harding was 81. Jetty Lucas was 85. Both women had been attacked in their homes. Both had died, and McCarthy had never been charged in either case. She still has not been. Jurors heard about them anyway, and that is a large part of why she was condemned rather than imprisoned. So how does a claim about who was allowed to sit on a jury go 15 years without ever being decided? McCarthy was convicted in 1998 and sentenced to death on November 24th of that year. That conviction was overturned in 2002 after an appellate court found her confession had been improperly obtained. The court did not question the physical evidence at all. It found that officers had kept questioning her after she asked for a lawyer, which made the written statement inadmissible, and that was enough to send the case back. Dallas County tried her again, this time without the confession, and got the same verdict. On November 1st, 2002, a second jury sentenced her to death for the second time. It was the composition of that second jury that would haunt the case. 4 black members of the veneer, 3 struck by the state, and a jury that ended up effectively all white. Her trial lawyer never objected and never asked for a Batson hearing, which is the procedure a court uses to examine whether jurors were removed on the basis of race. Her appellate lawyer, who by his client's account visited her once in 10 years, never raised it either. Because it was not raised at the time, the claim was procedurally barred, and no court ever ruled on whether it had merit. Her final federal appeal was denied in July of 2012. The Supreme Court declined to hear the case in January of 2013. 2 separate stays pushed her date from January 29th to April 3rd, and then to June 26, 2013, which is how a routine capital case became a global headline. Amnesty International issued an urgent action. Her attorney, Maury Levin, said publicly that the errors running through the case, meaning race bias, ineffective counsel, and courts unwilling to police the system, made it a shameful thing for Texas to hold up as its 500th execution. Booth's family took a different view. Randy Browning, Booth's godson, said the only significance the number held for them was that Kimberly McCarthy had taken Dorothy Booth away from them. The number that made her famous came from a count that began on December 7, 1982, when Charlie Brooks Jr. became the first person in the United States put to death by lethal injection. Every execution Texas has carried out since has been numbered from that night. 31 years later, the count reached 500, and it happened to land on a woman whose most serious appellate claim had never been heard. Aaron Michaels, the man she had been married to 2 decades earlier, was among the witnesses. She was executed at the Huntsville unit on June 26, 2013, with a single dose of pentobarbital, as statewide execution number 500 and prisoner 999287. In her final statement, she thanked her spiritual advisor, her attorney, and the father of her son, and told the room this was not a loss, but a win, because she was going home to be with Jesus. Witnesses said she added that God is great as the drug took hold. She was pronounced dead at 6:37 that evening, about 20 minutes after the injection began. A spokesman for the Texas Department of Criminal Justice said afterward that the agency had simply carried out the court's order. She was the first woman executed anywhere in the United States in nearly 3 years, the previous being Teresa Lewis in Virginia in September of 2010. As of today, Kimberly McCarthy is buried at the Captain Joe Byrd Cemetery in Huntsville, the prison graveyard used for inmates nobody claims. Her jury selection claim has still never been examined on its merits by any court, and the two 1988 cases used to secure her death sentence remain officially uncharged. McCarthy's fate was shaped in large part by what her lawyers never said out loud. The woman Texas executed next had the opposite problem. Because 6 people were charged over what happened to one man, 5 of them talked, and the state built its entire case on the argument that she had been the one giving instructions. Suzanne Basso. On the morning of August 26, 1998, a jogger in Galena Park, Texas found a man in a roadside ditch. He was fully dressed, but one shoe was on the wrong foot, and there was no blood on any of his clothing, which told investigators he had been dressed after he died. His name was Luis Musso. He had been in Texas for a matter of weeks, and he had come down from New Jersey because a woman had promised to marry him. Luis Musso, known to everyone as Buddy, was 59 years old and intellectually disabled. He had spent his life in Cliffside Park, New Jersey, some of it in an assisted living home, and he was a widower with a grown son. He met Suzanne Basso's family at a church carnival in New Jersey in 1998. He told people back home that he was moving to Texas to get married. Basso was born Suzanne Margaret Burns in Schenectady, New York, on May 15, 1954. She used a long list of aliases and worked at various points as a seamstress and as a security guard at an apartment complex. She married an ex-Marine named James Peake in the early 1970s and had 2 children with him. And in 1982, Peake was convicted of misconduct involving their daughter during her childhood. The family later took the surname O'Malley. In 1993, she attached herself to a New Jersey businessman named Carmine Basso, took his last name without ever divorcing Peake, and kept it after he died in 1997. She told people she was connected to the Rockefeller family and to the New York governor's office. And no, that is not an exaggeration for effect. Those were the specific claims she made. Musso arrived in Texas in June of 1998. Basso made herself the beneficiary of his life insurance and took control of his Social Security payments. From the moment he arrived, he was treated as unpaid labor, and over the following weeks, the treatment escalated. He was subjected to prolonged mistreatment over a period of days at a Houston apartment belonging to a co-defendant named Bernice Ahrens Miller. The autopsy documented a skull fracture, roughly 14 broken ribs, and bruising across his entire body. The cause of death was ruled multiple blunt impact trauma. His body was dressed and driven to the ditch in Galena Park. How long he survived in Texas is one of the few facts about this case that sources still cannot agree on. Some accounts put it at roughly 16 days from his arrival to his death. Others describe something closer to 10 weeks. Even the date the body was found appears as August 26th in some records and August 28th in others. What is not in dispute is that Bernice Ahrens later told police that Basso had made all of them agree to a pact, that none of them would say anything about what had happened. That pact lasted less than a day once officers started asking questions. There had been a warning. Days before the body was found, a Jacinto City officer came across 2 men leading a visibly injured Musso along the road on what they described as a military-style run. Basso arrived, identified herself as his legal guardian, comforted him in front of the officer, and everyone went home. Nobody followed up. When the body was found, it was Basso who walked into the Jacinto City police station to press her missing person report. officers pulled her son James O'Malley aside for a few minutes, and he told them flatly that they had done it. The assistant chief, Robert Pruitt, said later that O'Malley's complete lack of reaction at the ditch had already told him the young man knew what was in it before they arrived. How do you divide responsibility among 6 people when the state can only send one of them to the death chamber? That was the practical question the Harris County District Attorney's Office faced, and the answer shaped every trial that followed. 6 people were charged. Basso, her son James O'Malley, 23, Bernice Aarons Miller, 55, Miller's children Craig Aarons, 25, and Hope Aarons, 22, and Hope's fiancé Terrence Singleton, 28. Judge Mary Lou Keel ordered separate trials. James O'Malley was convicted of capital murder and given life. Terrence Singleton was convicted of capital murder and given life. Bernice Miller received 80 years for murder, and Craig Aarons received 60. Hope Aarons produced a hung jury, then pleaded guilty for 20 years in exchange for testifying against Basso. Prosecutors Colleen Barnett and Denise Nassar tried Basso as the person who had organized all of it. Barnett told the jury that Basso had run the show, that she had directed the others, and that she had wanted the money. Basso was convicted on August 27, 1999, and sentenced to death on October 28. Her behavior in the courtroom became its own subplot. She had weighed roughly 350 pounds at her arrest and used a wheelchair. During trial, she claimed she had gone blind and been paralyzed, and she answered questions in the voice of a small child. A court-appointed psychiatrist testified that she was feigning all of it. The judge found her competent to stand trial. Her own daughter testified during the punishment phase about the abuse she had suffered at her mother's hands. The appeals ran for 14 years and centered on mental competence. Her lawyers argued she was seriously mentally ill and that her trial counsel had presented nothing at all about her own impoverished and abusive upbringing. In January of 2014, a state judge reviewing her competence found a documented history of inventing stories and manipulating psychological testing. The Fifth Circuit refused to intervene. The United States Supreme Court rejected her final appeal roughly an hour before she was scheduled to die. She was executed at the Huntsville unit on February 5, 2014, as statewide execution number 510 and prisoner 9999329. Asked whether she had a final statement, she answered, "No, sir." She smiled at 2 friends who had come to witness, mouthed a word toward them, nodded, and then began to snore as the pentobarbital took effect. She was pronounced dead at 6:26 that evening, 11 minutes after the dose began. She was the 14th woman executed in the United States since 1976, and the 5th in Texas. As of today, Suzanne Basso remains the only one of the 6 people charged in Louis Mousseau's death who was sentenced to die. The rest received terms ranging from 20 years to life, and the case is still raised in Texas courtrooms as an example of how differently the same set of facts can be resolved depending on which defendant the state decides was in charge. Basso's case came down to who was giving the orders. The one that closes this list came down to a single word in the Texas Penal Code, and to whether that word could be stretched to describe what had happened inside an apartment in Arlington. Lisa Coleman. On a July morning in 2004, paramedics were called to an apartment in Arlington, Texas, where they found a child who could not be revived. What the medical examiner determined turned a welfare case into a capital case. But under Texas law as it stood at the time, none of it was enough by itself to put anyone on death row, so prosecutors reached for a different word. That word was kidnapping, and it is the reason Lisa Coleman was executed rather than imprisoned. The child was the son of Marcella Williams, who was Coleman's girlfriend. He had been known to Texas Child Protective Services for most of his short life, and the agency had looked into the household 6 or 7 times. He had been removed from the home once, in 1999, over allegations against Coleman. He was returned to his mother on one condition, which was that he not be around Lisa Coleman. Coleman was born Lisa Ann Coleman on October 6, 1975. By the account her own defense presented at trial, she was conceived in an assault, was abused throughout her own childhood, spent time in foster care, was called Pig by her mother, and was dependent on drugs and alcohol by 16. She had a 1993 cocaine possession conviction that carried 5 years, a misdemeanor evading arrest conviction in 1997, and a burglary conviction in 2000 that carried 2. She split her time between her own son and mother and the Arlington apartment she shared with Marcella Williams. On the morning of July 26, 2004, Williams called for emergency help and reported that the child was having difficulty breathing. Paramedics found that he had already died. The Tarrant County Medical Examiner's Office determined the cause of death to be malnutrition, with pneumonia as a contributing factor. What the investigation uncovered inside that apartment was staggering in scope. Investigators documented a pattern of prolonged mistreatment and evidence that the child had been restrained and confined for extended periods, including a pantry that locked from the outside. Stated in the plainest terms available, this was not a single incident. It had been going on for a very long time in a household the state had already been inside of 6 times. Here is where the case became a legal argument rather than a moral one. In 2004, Texas law did not treat the death of a child over the age of 6 as capital murder on its own. Something else had to elevate it. Prosecutors in Tarrant County chose kidnapping, arguing that the restraint and confinement themselves satisfied the definition, and that combination is what made Lisa Coleman eligible for a death sentence. Can a child be kidnapped inside his own home? That question went to a jury, then to the Texas Court of Criminal Appeals, then to the federal courts, and the answer never changed. Coleman was charged on September 22, 2004. She turned down a plea agreement and went to trial. In 2006, she was convicted of capital murder and sentenced to death. Marcella Williams, who had made the call that morning, pleaded guilty that same year to avoid a capital trial and received a life sentence with parole eligibility at the age of 65. The state's evidence included DNA recovered from an item in the apartment that matched both the child and Coleman. A sibling testified about how the household was run. A Child Protective Services investigator named Edna Campbell testified that Coleman had acknowledged restraining the child and physically harming him. The defense argued the death had been accidental, that the child had ongoing health and behavioral difficulties, and that the 2 women were unequipped to parent. A defense pathologist, Dr. Lester Winkler, attributed the death to aspiration pneumonia while conceding the malnutrition finding. For the state, the kidnapping theory was not a technicality. Texas prosecutors have to prove an aggravating circumstance before a death can be charged as capital. And in 2004, in a case like this one, restraint was the only aggravator available to them. Coleman's lawyers argued that stretching the definition that far converted an abuse and neglect prosecution into a capital case through legal construction rather than legislative intent. The gap between the 2 sentences became part of that argument as well, since the woman who lived in the apartment full-time and placed the call that morning was given life. On appeal, Coleman's lawyers went straight at the kidnapping theory. They argued that no kidnapping had occurred because the child was in his own residence, and they produced affidavits from 4 people at the apartment complex who said they had seen him outside and unrestrained in the days before his death. The Fifth Circuit rejected the affidavits, noting that they were nearly identical to one another and finding trial counsel's strategy reasonable. The Supreme Court declined to intervene. The Board of Pardons and Paroles denied clemency unanimously. Her attorney, John Stickles, argued publicly that the state had singled his client out and constructed a theory to reach a death sentence because she was black, gay, and an easy target. And he repeated that argument until the day she died. She was executed at the Huntsville unit on September 17, 2014, as statewide execution number 517 and prisoner 9999511. In her final statement, she told her family and her son that she loved them, told the women still on death row to keep their heads up, sent word to a fellow inmate that she loved her, said God is good, and asked that people be told she had finished strong. She mouthed a kiss toward her friends and an aunt, and she was pronounced dead at 6:24 that evening, about 12 minutes after the injection began. She was the 9th person Texas executed in 2014 and the 2nd woman that year, and the 15th woman executed in the United States since 1976. The case did not stop mattering when the sentence came down. It landed in the middle of a run of child fatality cases in Texas in the mid-2000s that put Child Protective Services under sustained legislative scrutiny, and it fed directly into a period of added funding and caseworker hiring in the years that followed. A household the state had already stepped inside 6 or 7 times is a difficult thing for an agency to explain. As of today, Lisa Coleman remains the most recent woman Texas has put to death. Marcella Williams is still serving her life sentence, and in 2011, 5 years after Coleman's conviction and 3 years before her execution, the Texas legislature changed the law so that the death of a child 10 or younger is capital murder on its own, which means the kidnapping argument that decided her case would no longer be necessary today. 6 women, 6 sets of appeals, and 6 trips to the same small room in Huntsville. Every case file here is public record, and every one of them is still being argued over. Thanks for watching. Click here for the next video.